Hi, my name's Steve Sidkin, and I'm going to be speaking over the next few minutes about franchising your business. Franchises exist both in respect of services and in respect of goods throughout the UK economy, as well as the economies of many other countries. However, franchises differ from most other sales arrangements, such as distribution or license, and they differ in many respects. But the main difference is that to the outside world, the franchisor and franchisee are the same. The franchisee uses the franchisor's business name or trademark for the franchised business. In addition, the franchisor regulates very closely the way in which the franchisee's business is carried on. As a result, the Big Mac that you might eat at the weekend is the same the world over. The purpose of this talk today is to give you a brief introduction to the potential opportunities and drawbacks, as well as the issues which need to be considered in a franchise agreement. Let's start with advantages and disadvantages. The main advantage for the franchisor is the ability to quickly scale a business, for example by moving into new territories whilst maintaining a large degree of control over the brand image of the product or services which is at the heart of the franchisor's business. And this is done through the control that the franchisor exercises over the franchisee. By way of example, a franchisor can determine the way in which goods are displayed in the franchise shop or online. When it comes to a shop, the uniforms which the franchisee's employees are required to wear, or even the way in which they are expected to greet customers. Other advantages for the franchisor are that it is the franchisee's capital input which reduces the cost and risks involved in expansion. Secondly, increased numbers of outlets enable economies of scale. It's also the case that the contribution made by the franchisees towards central training and advertising costs goes to reduce those costs so far as the franchisor is concerned. Fourthly, because the franchisee has a financial stake in the business, it can be expected that the franchisee will be more motivated to make the new outlet a success. But there are also benefits for a franchisee. For example, they are self-employed. Secondly, if the franchisor already has a well-known name, it is relatively easy to quickly develop the franchised business and less working capital will be required. Further, the franchisor may provide a high level of support relating to the management of the business. It's also the case that the purchasing power of the franchisor can reduce the costs of the franchisee, and there may be other scale-related benefits. Fifthly, if the franchisee knows that the name already sells, the risks are far lower. And as such, it is often easier to obtain financing. But of course, where there are advantages, we can expect that there will be some disadvantages. The main disadvantage for the franchisor is that there will be, to a certain degree, a loss of control. This is so despite the numerous restrictions which can be expected to be found in the franchise agreement on the franchisee. For this reason, the franchisor must be able to terminate the franchise quickly if the franchisee is harming the reputation of the business. It's also possible that a successful franchisee may be reluctant or may actually resist changes which the franchisor wishes to make or requires to make so far as the franchised system itself is concerned. In addition, an element of the franchisor's profit will be taken up by supporting another element in the supply chain, namely the franchise system and the franchisees who are part of it. It's also the case that a franchisee will gain a high level of knowledge about the franchisor's business, and it follows that there is a risk that they may later use this information for their own purposes in order to compete with the franchisor. Restrictions on the use of such information must be carefully drafted in order to ensure that they are as legally effective as possible. The franchisor should also be aware that running a franchise business may be quite different from running its own business. Certainly, some new skills will be required. Furthermore, the franchisor needs to recognize the disadvantages the franchisee may see in what is happening. The franchisee will be far more restricted in the way they run the business than if they were to run it independently. There may also be restrictions on the franchisee's ability to sell or pass on the business at some point in the future. The franchisee will be obliged to make regular payments out of the profits to the franchisor. It's also possible that the franchisor might run into financial or other difficulties, and this might impact the franchisee in turn. However successful the franchisee's operation, such difficulties will affect their business. Let's turn now to consider the main elements of a franchise agreement. Firstly, an exclusive right to sell the products or supply the services and use the franchisor's trademarks. There must be this particular provision in a franchise agreement. As a result, the franchise agreement will need to provide for the grant by the franchisor to the franchisee of the right to use the franchisor's name, alternatively a name associated with the franchisor. It can be expected that in order to protect both franchisor and franchisee, that this name will be registered as a trademark at the relevant trademark office. Further, the franchisor will agree not to supply the products to other parties in a given territory. Exclusivity can also be limited to particular lines of products or services. What about the franchisor's control? It is important both for the franchisor and for other franchisees within the franchise system that the franchisor retains a certain degree of control over how the business is operated. Certain provisions will be in the franchise agreement itself. Others will be contained in a franchise manual. The franchisor will have the right to update the manual from time to time, so retaining flexibility. Typical provisions include, firstly, control over choice of location, decoration and display of goods, appearance and behavior of staff, and opening hours, and similar provisions in respect of an online store. Secondly, the franchisor's approval will be required for advertising initiated by the franchisee. In respect of goods, it can be expected that there will be minimum stock levels and purchase requirements. What of assistance by the franchisor? The franchise agreement should provide for the franchisor to give certain assistance to the franchisee. This will necessarily include guidance in the matters over which the franchisor has control. The franchisor often also supplies equipment, training, publicity, and in the case of goods, stock for the franchisee prior to the commencement of the franchise business, and, where applicable, on a continuing basis. What of duration? Most franchise agreements are granted for 5 years or about 5 years, with a right to renew for at least one further period. A fee may or may not be payable on renewal. It's important that the initial franchise period is sufficiently long to give the franchisee a decent prospect of recouping its costs and, furthermore, ensuring that it obtains a certain degree of return on its investment, an investment both in terms of money and in terms of time. Renewal itself should be conditional on the franchisee achieving certain performance levels. Turning to the issue of payment, the franchisee normally makes 3 types of payment to the franchisor during the course of the agreement. Firstly, an initial fee. The purpose of the initial fee is for the franchisor to cover its expenses in promoting the franchise. The initial fee is normally kept reasonably low, with perhaps 10 or 15% of the fee being attributed to the grant of the trademark license. Secondly, there will be continuing fees. This is the royalty element and is usually charged as a percentage of the franchisee sales. This fee reimburses the franchisor for the cost of supporting the franchise on a continuing basis and also represents its profit. Alternatively, the franchisor may not require royalties but simply supply goods to the franchisee at a price which covers its costs and contains an element of profit. The franchise agreement will normally include minimum sales in the case of a royalty arrangement or minimum purchase in the case of a supply arrangement provisions in order to protect the franchisor's profits. There's also the possibility of an advertising charge. An advertising charge is made in respect of national or regional advertising undertaken by the franchisor, often based on the turnover of the franchisee. The franchisee can check that the payment is used for these purposes, as it is usual for the franchisor to place such payments in a special bank account. In addition, there may be a fee payable on the renewal of the franchise agreement. The franchise agreement will generally provide for interest to be charged in the case of late payment. Also, in respect of finances, there can be expected to be included in the franchise agreement provisions concerning accounts. The franchisor will want to inspect the franchisee's accounts and sales records and regulate the way in which these records and accounts are produced, as well as satisfying the franchisor's interest in the financial health of the franchisee. This is also essential for the proper calculation of royalties and advertising charges. Insurance. The agreement will normally require the franchisee to take out insurance in respect to the assets of the business and liabilities to the public. There's also risk that because of the degree of control exercised by the franchisor over the franchisee, and given the fact that in the mind of the public there is no distinction between the two, the franchisor could be held liable for the franchisee's negligence. Accordingly, the franchisor will usually wish to obtain insurance to cover itself against such a risk. What of transfer, or to use the legal term, assignment? The franchisor will not usually allow the franchisee to dispose of the business without the franchisor's consent. The franchisor will want to ensure that the prospective purchaser of the business is suitable and financially sound. The franchisor commonly retains the option of equaling any offer made for the business and purchasing it itself. If it should be the case that the franchisor is also the landlord of the franchisee, it will be concerned that the franchisee does not acquire security of tenure of the premises from which the franchise is undertaken. This is because if the franchisee were to have security of tenure, they could demand the renewal of their lease on its expiry, even where the franchise agreement itself had terminated. Security of tenure can be avoided through a straightforward court application by both the parties for approval of the arrangement. Turning to termination. Most franchise agreements provide the franchisor with wide and absolute powers to terminate the agreement quickly and easily if the franchisee is not performing satisfactorily. In case of poor performance, as a step falling short of termination, the franchisor might retain the right to appoint an acting manager to go into the franchise business to try and remedy the situation. It's also important to consider bank guarantees and guarantors. The franchisee will often be a company with limited liability. In the event of the franchisee becoming insolvent, the franchisor will rank as a normal creditor in the insolvency. Accordingly, the franchisor should take steps to ensure payment of the monies owed to it. It's normal to request a bank guarantee in an appropriate sum. A personal guarantee of the franchisee's obligations, who will normally be the person running the franchise, should also be considered. Turning to the regulation of franchising, the good news is that, so far as the UK is concerned, there is no specific legislation relating to franchise agreements. Franchisors and franchisees may apply to join the British Franchise Association, although membership is not required by law. Members of this body undertake to adopt a code of ethics. In addition, the association provides a forum for the interchange of information and franchising expertise. Despite the lack of legislation specifically relating to franchising, other legislation will impact on franchise agreements. The principal one is that of competition law, both so far as the UK is concerned as well as outside of the UK. And leading on from that, a franchise system does provide a remarkable opportunity for UK businesses to expand overseas and to reap the advantages about which I spoke earlier on in this talk. Thank you very much for listening to me, and if you have any questions, please feel free to contact me at slsidkin@foxwilliams.com. Thank you.